Welcome back to this course on copyright and related rights law. In this week, we are looking at the concept of originality, the various ways in which copyright can subsist in subject matters which are literary works, dramatic works, musical works, and artistic works. Let us first do a quick exercise on subject matter identification. What we have been able to achieve, hopefully, in the first 4 weeks of our discussion on subject matter is that when we see a creative expression, are we able to place this expression within a category of subject matter or not? Once we understand this, we will then look at the component of originality as a requirement for subsistence of copyright. Let us start this exercise. Consider this image. You can see books. Is everyone able to place books within the subject matter of literary works? What about this? Are you able to place it under artistic works? Some of you may also have been able to not just place this under artistic work, but also classify it as a sculpture within artistic work. What about this? Again, many of you must have figured that this is an artistic work, and still many of you may have been able to identify that this is a drawing. What about this? I'm sure you are all able to identify this as a musical work. The graphical notations on this sheet music do not confuse you anymore, as you know that graphical notations, even though they are written or printed in notational form, they are included in the definition of musical work. What about this? You will be able to place this within the subject matter of dramatic work. How? Since this is a dance performance, considering the requirements of dramatic work, such as that of fixation, are satisfied, then this can be characterized as a choreography, which is a dramatic work. This quick exercise helps place clarity on our progress in the weeks that we have had in terms of our ability to classify expressions within literary, dramatic, musical, and artistic works. Many of us are also in an additional position, able to subclassify the expression within a particular category of subject matter. What we are doing now, this week, is that we are stepping forward from the ability to classify subject matter to the ability to understand when copyright will subsist in such a subject matter. After all, the possibility of an expression becoming a category under the Copyright Act, such as a literary work or an artistic work, is only the first step. The more important step comes in the form of originality. Take a look at this image. You can see that on a notepad, this person has written a short note. The short note, as you can read, is every day the sun sets, but the destination always changes. So at last, add a new destination to your list. How is this expression similar to this expression? Or is it similar at all? In your mind, you must have been able to make a distinction between the type of subject matter, but in your mind, you might have also been thinking about the simplicity of these works when compared to their counterparts in the previous illustrations. For example, when you consider a book of 100, 200 and of 100, 200, 250, 300 pages in comparison to an expression in a single page of a few words, is this a simplistic expression in comparison? Similarly, is this a simplistic expression in comparison to this or this? The question we are trying to answer is that when we compare expressions, are we able to answer a question, which is, should copyright subsist in these expressions? Because at the moment we say copyright should subsist or should exist, we are saying that a term of the author's life plus 50 or 60 or 70 years, depending on which Copyright Act you're looking at. For that period of time, copyright will vest with a certain person. Because copyright has the power to prevent communication of the work which is unauthorized or reproduction of the work which is unauthorized, it can place a lot of power in the hands of the copyright holder to prevent dissemination of information. In fact, some would argue it could also freeze creativity. Therefore, should the same kind of protection be provided to these works when the comparison is with these works? Let us consider, what if copyright should not be granted? What are the possible reasons that we are thinking of when we are saying that copyright should not be granted? Are we saying that not a lot of skill is required to write what we have written here? Not a lot of skill is required to do what has been done here? In comparison, a lot of skill is required to do this or to do this. Similarly, what about the effort? This may have not taken a lot of time and labor, but this would have taken a lot of time. This too would have taken a lot of labor, a lot of time. What about application of mind in terms of whether certain variables should be present within a particular expression or not? Is that aspect of judgment present in these particular expressions as compared to these? What you must have considered as a basic difference between these expressions and the ones earlier is that they are generally more simplistic. And in supplementing this understanding that it is simplistic, we seem to be justifying it on account of the skill taken to make that particular expression possible, the effort expended to make it possible, and the application of mind or the judgment in place to make it happen. Let us consider the opposite stance. What if we say that copyright should be granted? In this situation, we are saying that irrespective of a particular standard of skill, irrespective of a particular standard of effort, irrespective of any subjective judgment application that we are considering, for a person to write this particular statement, or for somebody to draw this, they are factoring in their own sense of information about their surroundings, and they are placing it on account of their expression. So there is nothing that is denying the application of the category of artistic work to this expression and of literary work to this expression. But when the question is of copyright subsistence, do we in fact think that there should be some kind of a test and not all expressions should be copyrighted? On that point, let us come back again to our first stance, that copyright should not be granted. What is the problem? Why is it not that we can grant copyright protection or think of the grant of copyright protection to all expressions, irrespective of the skill, the expression, irrespective of the skill, the effort, or the application of mind or judgment? We must understand that the grant of copyright is a state-granted monopoly. Its effect, if not properly awarded, can be chilling. Advocates of freedom of expression target copyright as a possible tool that can be used to restrict the growth of expression. And how is this possible? Where copyright holders use copyright to prevent dissemination of creativity. Without substantial access to a copyrighted work, it is possible for the argument to be placed that copyright can actually be used against the growth of creative expressions. And therefore, can we say that there is a social benefit in restricting copyright grant to those expressions which are not commonplace expressions? What then do we mean by commonplace expressions? Are we saying that there is some kind of a level or a threshold that needs to be satisfied if an expression can become copyrightable? If a common idea can be expressed very simply, there can be n number of ways in which that common idea can be expressed in similar ways. They are different, but they are more or less similar, representing what is very common. On a question of whether there is any skill needed, if the answer is no, if there is any effort that is needed in terms of time and labor, if the answer is no, is there any application of mind needed? If the answer is no, then is it not in society's benefit to place some kind of a level, the satisfaction of which will carry an expression forward towards subsistence of copyright? But how do we determine this level? In fact, any kind of application brings to our mind the need for something uniform. It's something that we must be able to apply. Is it possible to have some kind of an objective test which can be used across literary works? In other words, what would be the basis for some kind of a uniform division of copyrightable literary works from non-copyrightable literary works? Similarly, with respect to artistic works or musical works or dramatic works, could it also be possible to have a uniform division with respect to all expressions irrespective of the subject matter? Let us go back and do a quick revision on a case that we have discussed in our previous sessions. In University London Press versus University Tutorial Press, the court had indicated a two-layered application. According to the court, a first layer wherein an objective assessment needs to be done on whether an expression can be categorized as a type of subject matter. Therefore, we all know now that if an expression is made in words, if it is written, if there are symbols used akin to words or numbers that are used, irrespective of literary quality, it would be a literary work. And the next layer would be to consider whether it is original. Now, what is original? The court had explained. The word original does not, in this connection, mean that the work must be the expression of original or inventive thought. Copyright acts are not concerned with the originality of ideas, but with the expression of thought. And in the case of literary work, with the expression of thought in print or writing. The work must not be copied from another work, that it should originate from the author. Based on this two-layered understanding, and especially the explanation of what is original, we are splitting this into a two-dimensional study. The first dimension focuses on independence of creation. You can see here in the last excerpt, it says the work must not be copied from another work, that it should originate from the author. Consider two works which are seemingly identical, if not identical, substantially similar. Is it not possible for these two works to be independent? We have discussed this point in an earlier session as well, where you would recall we were discussing the possibility of two people who stay geographically in very different locations, and there is a high possibility for these two people to not have had any contact, and any expression that may have originated from them, they might not have been aware of it. Even with the presence of digital media and communication, it's possible that they have not had access to the work. Even then, it could be possible that two people could come at a substantially similar expression without having any access to each other's work, in which case independence of creation is satisfied. Which means what? That a work simply need not be copied from another work in order to be called original. Or in still another words, as long as we can trace the work back to an author, is that author the point at which that specific expression has originated? How do we prove this? By proving non-access. That these two individuals who are claiming to be authors of two substantially similar works have not had access to each other, which proves that their works have not been copied. And if they have not been copied, then it shows that this work has been independently created and therefore it is original. So you can have not just two, you can have 3, 4, 10, 100, n number of expressions which are substantially similar. And as long as they are not copied from each other, they will be considered original. Do you see any problem with this application? Let me rephrase. What are we trying to achieve here? We have identified that an expression is fitting within a category of subject matter under copyright. Say, for example, we are saying that an expression is a literary work. This is an objective assessment, the first layer. The second layer is a question of whether copyright can subsist in such a literary work. In this second layer, if we are only concerned with the question of whether the link between the work and the author, that is, the expression or the work is originating from the author and it is not copied from somewhere else, is enough for copyright to subsist in it. What we will be left with is a layer of different works which are so substantially similar that you would have to grant it copyright protection despite the fact that there are n number of possibilities of substantial similarity. What we will look at in the next session is whether this first dimension can be remedied by any kind of a threshold or a level that can be placed in addition to the question of whether there has been copying or not. And that is a question of creativity. Thank you for joining me. See you all in the next session. Thank you.